you see it now? I can't really, there's no room to turn it. Is that okay? No, okay. Oh shit, something just fell off it. I don't know what just fell off. I don't know, I just laid it on top.
No.
Okay.
Sometimes, like, if you plug it in and it's already been on, it doesn't see it, so if you power back, cycle it, come all the way back down and come back up.
All right, let's try that.
Hey there,
Perhaps with me a lot.
I'm ready to establish this connection.
I'm going to restart it because it's not showing a picture right now. The power's up real quick.
Yeah, he hasn't switched across to... Yeah,
I'm going to do that one. Because the screen is showing on everyone else's but ours. You got it.
calling People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Your Honor. Alan Jackson, on behalf of Mr. Reiner, who is present in court out of custody. I'm sorry, in custody.
Thank you.
Good morning, Your Honor. Habib Balian for the people.
Your Honor, we have a matter of housekeeping that I'd like to address in chambers in dealing with the 10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. We have no principled objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that body attachments be issued.
I don't have the list. I'd like to get a copy, and I haven't seen the proof of service, but I assume the court.
Counsel for 4 and 10 present.
Yes, Your Honor. I'm not sure which number I am.
Number 10.
I'm counsel for number 10, and we do object to issue if that would resolve the court's concerns about retaining jurisdiction. However, we see no reason, given our appearance and the fact that we are here to issue a hold of body attachment.
And counsel for number 4.
Thank you.
In Counsel number 10's statement, I don't see the necessity for issuing a body attachment. I too will stipulate the jurisdiction without necessarily waiving any objections we ultimately may make. But given my newness to the matter, I don't see the necessity of having a court order issued against an individual in this circumstance.
Fair enough.
Thank you, Your Honor, and just to be clear, we do also reserve all of our objections.
Yes, and so, but as to the remaining numbers, that's 1, 2, 3, 5, 6, 7, and 8. Those, the court will issue body attachment and hold it until the next court date.
And 9.
And 9.
And 9. Thank you. We have no objection to counsel's representations, given the fact that both have graciously submitted to jurisdiction with regard to 4 and 10. We think that's appropriate.
Thank you. Once again, the court will issue and hold 3, 5, 6, 7, 8, and 9.
Thank you.
Until the next hearing date. And we'll
Does the
seal.
court have a list?
It does, and the court will seal that list as well.
We've asked,
People have a copy, Your Honor?
we've asked that the court seal it specifically because it is ongoing defense investigator data or evidence that we recover or we get. Our counsel, on behalf of Mr. Reiner, gets, and that is discoverable. We'll comply with all, or counsel will comply with all discovery obligations at that time.
Can you address the counsel's request to provide a copy to the people?
That's the point. We think that should not be done because that would implicate ongoing investigative efforts by the defense, and it would compromise Mr. Reiner's right to a fair trial and his right to maintain his investigation with some level of confidence or confidentiality, I should say.
So at this time, the court would just seal it until the next court hearing date.
Thank you.
And how else would you like to proceed?
Your Honor, at this time, I, on behalf of Workman Jackson and Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel of record based on the conversation that we've had in chambers and the explanation that we've provided to the court in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved. The Public Defender's Office has been notified. We've had conversations with them. They are here. They're staffed. They're ready to take over. My understanding is they are ready for the appointment immediately, forthwith.
Good morning, Your Honor. Kimberly Green from the Public Defender's Office. That is correct.
So the court will case, and so that firm is relieved as counsel of record, and the court appoints the Public Defender's Office to represent Mr. Reiner.
Thank you, Your Honor.
Current counsel turnover, any items that they receive.
We will absolutely comply with that. We've already begun. The engagement has been met.
Your Honor, there's a protective order issued by the court in place regarding the handling of discovery, order that's remaining in place for now, and we will serve a copy of that on the Public Defender's Office along with the discovery we provide.
Yes, the court will order that order.
Preclude me from giving, Mr. Balian raises a very sage point. I'm under a protective order not to provide our discovery to anybody else. That would text providing the information only to Ms. Green in her office. Then I can be in full compliance with the protective order.
Anything to the people, any response to that request?
No problem. I believe the protective order spells out that it covers Mr. Jackson's firm as well as any successor counsel.
Thank you.
you can provide everything to Ms. Green.
Thank you.
Thank you. Anything further? Back on the record in People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Kimberly Green, GRTE, the Public Defender's Office, on behalf of Mr. Reiner, who again is present.
Thank you.
Good morning, Your Honor. Habib Alien, representing the people of the state of California.
Thank you.
Your Honor, with the court's permission, we'd ask to put over the arraignment one last time to February 23rd, if that date is appropriate.
That date is fine for the court.
Thank you, and I will work with Ms. Green to get her discovery prior to that date.
I'll take a waiver for you. Entitled, you have a constitutional and statutory right to a speedy arraignment. Your counsel, Ms. Green from the Public Defender's Office, is requesting that your arraignment be continued to February the 23rd, 2026. In this department, do you waive your right to be arraigned today so that your matter may be continued to February 23rd, 2026 for arraignment?
Yeah, I agree with that exact one.
Thank you. And does counsel join that waiver?
I do, Your
The
Honor.
court finds that the defendant has made a knowing and intelligent waiver of his right to a speedy arraignment, and that his counsel of record joins in that waiver. Matter set for arraignment in this department, February 23rd, 2026. Bail remains at no bail. Anything further?
No, Your Honor.
Okay, thank you.
Thank you.
That's the end of that one. So I'll loop it. Top.
This is your right producer, the fee for the court proceedings.
Set up. We're ready. So calling People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Your Honor. Alan Jackson, on behalf of Mr. Reiner, who is present in court out of custody. I'm sorry, in custody.
Thank you.
Good morning, Your Honor. Habib Alien for the people.
Hold on to proceed.
Your Honor, we have a matter of housekeeping that I'd like to address in chambers in dealing with the 10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. We have no principled objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that body attachments be issued.
What do you think of the people?
I don't have the list. I'd like to get a copy, and I haven't seen the proof of service, but I assume the court.
Counsel for 4 and 10 present.
Yes, Your Honor. I'm not sure which number I am.
Number 10.
I'm counsel for number 10, and we do object to issue if that would resolve the court's concerns about retaining jurisdiction. However, we see no reason, given our appearance and the fact that we are
Test 1, 2, check, check, check.
Good, how are you?
I mean, when I might be exposed to the process. I mean, what's he gonna say? I'm done? But it's that's the other thing. That's the lady in the jacket. Alan, what's your code for your phone?
Be louder. short, but it should just be in. Yeah.
How's it going? Are you guys building a wall?
Yeah, that's what we're gonna do. This gentleman suggested it. So if you want to join our
I'll join your wall, yeah.
You don't have to look at the guy, which I don't want to do. I think that's fair, because like the statement itself, even verbatim, doesn't hold much more weight than saying that the contract there is not commenting, but it's not happened today.
But they're not reacting.
Just saying.
I'll say that. They're not reacting to vaccine. Thanks.
Back by the elevator, so.
Oh, he might have help set up.
Which I mean,
Like a live shot?
Yeah, so we could get this and you could do something else. Let me talk to him real quick.
Yeah, because even
That's what I mean.
there, yeah.
That's what I mean. Do something up there for 11 for you.
Yeah, if you want to get organized with them, then I'll let them know, like, hey, because they might take this and plug it in.
And then make sure it's got a
For random purposes, does not react. Jackson is fine. Is he coming? It did lose the Alright, he's coming.
Yeah, right here, right here.
Good morning. As you know, my name is Alan Jackson. This morning, I had to withdraw as Nick Reiner's counsel. Circumstances beyond our control, but more importantly, circumstances beyond Nick's control, have dictated that, sadly, it's made it impossible for us to continue our representation of Nick. I'm legally and I'm ethically prohibited from explaining all the reasons why. I know that's a question on everybody's mind. We expect the public defender to step in. They've already been appointed and very capably protect Nick Reiner's interests as he moves forward through the system. But be clear, be very, very clear about this. My team and I remain deeply, deeply committed to Nick Reiner and to his best interests. In fact, we know, we're not just convinced, we know that the legal process will reveal the true facts of the circumstances surrounding this case, Nick's case. You know, a lot's been printed of late, over the last 3 weeks. A lot has been printed about Nick, printed about his family, printed about the circumstances. Speculation is in print. On December 15th, in the early morning hours, I was in New York at the time, and I got a call. Me and my team, we dropped everything. And for the last 3 weeks, we have devoted literally every waking hour to protecting Nick and his interests. We've investigated this matter top to bottom, back to front. What we've learned, and you can take this to the bank, is that pursuant to the laws of this state, pursuant to the law in California, Nick Reiner is not guilty of murder. Print that. Print that. We wish him the very, very best moving forward. And that's all I have today.
And another thing.